for the complainant to prove that the doctor did not exercise reasonable care in accordance with the principles mentioned above. But for convicting a doctor in a criminal case, it must also be proved that this negligence was gross, amounting to recklessness.
No, this is not the stage, not that stage. This is not the conviction stage. Only charge sheet has been filed against you.
And finally, also a recent
Okay,
judgment
okay,
of
we'll hear you. Let the record come.
Lordship, just a small prayer, because the doctors have to come to the court, they have to leave another patients and come and stay here for the whole day, Lordship.
Maybe. In this petition under section 482 CRPC, the petitioner, namely Dr. Mrs. Nirupa Judhani, has applied for watching the first information report of Horlomuk PS case number 562 stroke 2018 dated 15/7/2018, and the charge sheet number 03 of 2020 dated 23/1/2020 corresponding to PRC case number 7478 stroke 2020 under section 304A IPC pending before the Court of Learned Additional Chief Judicial Magistrate Kamrup M. Guwahati. Where is the petition and the documents placed on record? Let notice be issued to the respondents returnable in 4 weeks. Step upon respondent number 2 be taken by registered post and also by usual process within a week from today. No formal notice is required to be issued to the respondent number 1 since Mr. P.S. Locker learned additional PP appears and received notice. However, extra requisite copy of the petition be furnished to him during the course of the day. Registrar will call for the scanned copy of the record from the learned court below. Interim pair of the petitioner will be considered after receiving the record from the learned court below.
Question.
Letter number 17.
You can take back these judgments and you can submit it at the time of hearing.
17.
May I please your Lordship? Lordship, 438 application, Lordship, and FIR is at page number 9, Lordship. Allegation is that the petitioner had issued 2 numbers of check, Lordship, to the informant, and later on those checks were bounced, Lordship. But Lordship, apart from his FIR, Lordship, thereafter the informant had filed one NI case before the learned CJM Tinchukia, Lordship, which is pending till now, Lordship, and in that case, Lordship, I have appeared and I am allowed to go on bail, Lordship, and I am participating in that case, Lordship. So, Lordship, in connection with same case, Lordship, 2 cases are pending, Lordship.
Okay.
And this
Yes,
particular
Mr.
case
Laskar.
NI case already proceeded, Lordship.
proceeded, and earlier they had
Third
filed
case,
this FIR, Lordship.
your good name, please.
G. Deccan, Lordship.
Learned counsel for the applicant and also heard Mr. P.S. Locker, learned additional PP for the state respondent. Apprehending arrest in connection with Hodia PS case number 151 of 2023 under section 406 IPC. This application under section 238 CRPC is preferred by applicant Raman Kakakoti for grant of POS bail. Be it noted here that the aforementioned case has been registered on the basis of one FIR lodged by one Sri Bimal Gogoi on 6/8/2023. The essence of allegation made in the FIR dated so and so is that the informant is supposed to receive a sum of rupees 4 lakhs for business purpose from the applicant. No, from the accused. And the accused has handed over two numbers of check bearing number 889549 and 889550 of his bank account bearing AC number 20350331910 of SBI Bayata Sarel.
Oh,
And when he presented the check in with his banker for encashment, then the same returned unpaid due to insufficient fund in the account of the accused. The learned counsel for the applicant submits that in connection with the said incident, the informant has already filed one case under section 138 NI Act before the learned, where it is pending,
CSM Tinsukia Lordship.
learned Chief Judicial Magistrate in Sukia. And in the said case, the applicant has already entered appearance and standing trial. And in the said case, he has already been granted bail. And that he is ready to cooperate with the investigating agency in this case, and therefore it is contented to allow the petition. On the other hand, Mr. Locker learned additional PP submits that since the applicant has already facing trial in connection with the NI case number 151 of 2023, instituted by the informant of this case before the Court of Learned Chief Judicial Magistrate in Sukia. And as such, he has no objection in the event of granting the privilege of arrest bail to the applicant. Having heard the submission of learned advocates of both sides, I have carefully gone to the petition and the documents placed on record and also placed on record. And it appears from the annexure 2 of the petition application that the informant has already instituted one case, being NI case number 151 of 2023 in the Court of Learned Chief Judicial Magistrate in Sukia. For dishonor of the sects issued by the applicant to him. Wherein the applicant has statedly standing trial now. And in view of above and also considering the facts and circumstances on the record and the nature and gravity of the offense, this court is inclined to allow this petition. It is provided that in the event of arrest of the applicant in connection with Odea PS case number so under section so he shall be released on arrest bail on his executing a bond of rupees 50,000 with one security of like amount to the satisfaction of the arresting authority. The above privilege is however subject to the following three conditions. Last condition, it shall not leave the jurisdiction as is M. Hodia without prior permission.
Item number 6 for admission.
Lordship, he is the resident of Lordship, Kamrup district Lordship.
Maybe, but you have to obtain permission from Azizam Hodia because the case was registered there.
Item 6 for admission.
Lordship, here in this case, Lordship, LCR come Lordship, receive Lordship, but I've tried to gone through the LCR Lordship, but it is totally illegible Lordship. Lordship, you can be very Lordship. The LCR, it cannot be read a single line I could not write it. Lordship. All pages are illegible Lordship.
So the petition is for quashing the proceeding.
Yes, my lord. Already, my lord, matter has been amicably settled, my lord.
Settled.
Between the parties. Yes, my lord.
You have filed affidavit.
Yeah, no, my lord. Respondent number 2 and 3 is filed already affidavit, my lord. That is on
Affidavit.
record, my lord.
So you have no objection in the event of allowing this petition? No objection. So, Mr. Lawford, what to do? Oh, what are the offenses?
My lord, 279, 304A, stroke, 338 IPC, my lord. Motor vehicle accident, my lord, and that the husband of the, my lord, respondent number 2, my lord, sustained injuries and succumbed to his injuries on the next day, my lord. And respondent number 3 also sustained injuries, my lord. And immediately after lodging the FIR, my lord, or the injured person, respondent number 3, and the respondent number 2, my lord, along with the family members of the accused person, my lord, that is the petitioner, my lord, approached before the my lord, officer inserts to withdraw the case. But my lord, in the meantime, my lord, FIR has been registered, and subsequently, as per FIR, my lord, allegation, my lord, they have submitted charge sheet, my lord. Now the PRC case is pending before the learned Chief Judicial Magistrate, my lord, at Mosulpur, my lord, Baksat Mosulpur. Lord, yeah, so many, my lord, judgment of our High Court, my lord, in this aspect, my lord. Kindly see the FIR at page 11. Page 11.
But some manipulations are there in the affidavit. Who is Junali Bora?
My lord,
Who identified the informant?
so they have not equally
Pardon?
yes. Yeah, most probably he is on behalf of P. Kolita. P. Kolita could not come today.
She's out of station, lordship.
These manipulations are there in the affidavit.
He will then,
Hmm?
he will then. He just didn't have another.
Oh, that's not common for-
Also today his name, this London Council's name is not as the they are in the cause list, lordship. So lordship,
His name is not there.
his name is not there, lordship. So lordship, we can fix it on any other date also so that the
Okay, as prayed for by Mr. P.S. Locker, learned additional PP for the state respondent. Rest is the matter on when Miss P. Kolita will be available.
Day
When?
after tomorrow.
day after tomorrow.
Day after tomorrow. Okay. There is allowed rest is the matter day after tomorrow.
Obliged, my lord.
For bail hearing, item 7.
Meet visual also. So the FIR is at page 15.
Page number?
FIR is at page 15. 1515.
When he was arrested?
My lord, on 1st of April, my lord.
April. What are the sections?
My lord, for 381. 381, my lord, basically relates to an employee, my lord. Now this
Employee.
This petitioner before your lordship is neither an employee nor way any way connected with the informant. My lord. What has happened when he went to the police station to, the main accused was arrested, my lord, the named accused. When he went to the police station, being a acquaintance of him, my lord, the public created pressure and he was arrested. My lord. Even in the forwarding report, my lord, if your lordship peruses the forwarding report at page 20, his custody has not been sought for by the police.
No, that is not the ground for enlarging him.
May I just read out the FIR for once, my lord?
Yes,
Page 15. With reference to the above, I, Mr. Quddus Ali, Mohammad Hakim Uddin, resident of village Muramari PS Lakhimpur district Gwalpara, Assam, would like to inform you that on today, at about 1 p.m., I hired one 407 mini truck bearing number AS28C, so it's a 9533 from Pathabari for purchase of ginger from Shillong. When I reached Brahmaputra Bazar for my some collection, for collection purpose, the driver of the vehicle, Mr. Ashraful Ali, is a different person. Ashraful Ali suddenly fled away, leaving me at Brahmaputra Bazar, where I took one bag in the said vehicle, where an amount of rupees 10,50,000 only kept in the said bag, and fled away from the spot. Until now, no any information received about him, and the mobile number of the said driver remains switched off. The driver is already known to me from last 1 year, and he always collect and transact money as per my order. This is the first incident he did against me. In this connection, I request you to kindly to investigate the matter immediately and trace out the culprit and help me to recover my total amount from the said culprit. So I therefore request you to kindly investigate the matter and take necessary action against the said accused driver as early as possible. Now, on the basis of this FIR, my lord, the case has been registered under section 381. Now, the petitioner before your lordship is
so 381 may not be attracted because he appears to be not his servant.
and
But
he has no
why
connection.
why this 379 IPC will not be attracted here?
Well, first of all, my lord, the petitioner before your lordship, he has not even been referred to in the FIR. He has got no connection with the offense, my lord.
No connection.
No connection. I have averred, my lord. He is
So,
also a driver.
where is the forwarding report? now?
Forwarding lordship page 20, my lord.
CD we have received. CD we have received this.
City receipt. Is there any material against him?
Lordship, he has stated, Lordship, that he, on the day of that incident, Lordship, the main accused person Ashraful, this person is the brother of that Ashraful, Lordship.
No, no,
Main accused person.
no,
He, as per his statement, Lordship, and when he stated, Lordship, that driver asked this person, this petitioner, that I have got one bag containing more than 10 lakhs rupees, what to do? Then this person had asked him to get the bag and come. Come. Thereafter, this person again made him. This accused person made him. That accused person made original accused person made this person, and thereafter also he had seen that money, but he has stated also, I have not. He did not give me money. As per his
I think
advice,
the
he has
money has been
taken the
recovered. That money has been recovered.
money
from the
recovered, Lordship,
from
but
the
not
original
the
accused.
entire amount. 10 lakhs rupees was stolen.
Recovered.
Not 5 lakhs rupees recovered, Lordship, from his house.
From the accused, main accused,
Main accused,
from the prime accused.
Ashraful's house.
If I am to read out the forwarding, my lord, for once, my lord, page 20.
I have-
Yes. So this ground of arrest?
Ground of arrest has been, my lord, just on top of the ground of arrest, my lord. Further, I beg to pray your honor that the said FIR named arrested accused person Ashraful Ali may be kindly be allowed for police remand for 5 days throughout interrogation to find out more clues of the case as well as to apprehend the other co-accused who are involving in this case. So, my lord, the petitioner was already arrested, but there was no prima facie material against him.
And he got the Ashraful from his that place, and he on his bike, Lordship.
It's only already 24 days, my lord.
Was all along involved in this crime. And still, yet there is a 5 lakh rupees yet to be recovered, Lordship. Only 5 lakh rupees
And
recovered.
the petitioner is in jail custody.
So what is the stage of investigation?
Lordship, in the stage of investigation is the Lordship. The money has to be, all money is not yet recovered, Lordship. And
Hmm.
otherwise, the statement of the accused person has been recorded, Lordship.
Witnesses are examined.
Lordship.
Can I say the case ID? Heard Mr.
G. Rahul, madam.
G.
G. Rahul.
Rahul, learned counsel for the accused, and also heard Mr. P.S. Locker, learned additional PP for the state respondent. His application under section 439 is prepared by accused Zulhaz Ali, who has been languishing in jail in connection with Wasista PS case number 212 of 2024 under section 381 IPC. It is to be noted here that above noted case has been registered on the basis of one FIR lodged by one Kudus Ali on
30, madam. 33 to
on
2024.
30th May 2024. The sense of allegation made in the FIR dated so and so is that on that day, that is 30th 3 2024 at about 1 p.m. he hired one 407 mini truck bearing registration number AS 28 stroke C9533 from Katabari for purchasing ginger from Ceylon, and when he reached Brahmaputra Bazar for collection of some amount. No, for some collection, then the driver of the vehicle, Mohammad Asraful Ali, fled away, leaving him at Brahmaputra Bazar. And no, with his bag containing a sum of rupees 10,50,000. And his mobile number was found to be switched off later on. Mr. Rahul, learned counsel for the accused, submits that the accused was arrested on 1/4/2024, and since then he has been languishing in jail as for last 3 days, and that he is no way involved with the offense alleged in the FIR. And the main accused has already been arrested by police, and some of the amount allegedly stolen in the vehicle has already been recovered by police, and that he will cooperate with the investigating agency, and therefore it is contended to allow the petition. Whereas Mr. P.S. Locker, learned additional PP, has produced the case review for this court and submits that the IO has collected sufficient incriminating materials against the accused, and that half of the stolen amount is yet to be recovered, and investigation is going on, and therefore Mr. Locker has opposed the petition. Where having heard the submission of learned advocates of both the parties, I have carefully gone through the petition and the documents placed in record, and also perused the case ID with the assistance of Mr. Locker, learned additional PP. It appears from the record that the FIR name, no, it appears from the case diary that the FIR name accused Pramod Asaful Ali has already been arrested, and a sum of rupees 2,99,500 was seized from his possession on 2/4/2024, and another sum of rupees 2 lakh was recovered and seized from his possession on 2/4/2024. And in view of the materials collected so far in the case diary, as well as the stage of investigation, further custodial detention of the accused seems to be not warranted here in this case, and therefore this court is inclined to allow this petition. It is provided that on furnishing a bond of rupees 50,000 with one security of like amount to the satisfaction of the Learned Chief Judicial Magistrate Kamrup M, accused Zulhas Ali be enlarged by in terms of above this BA instance, dispose of the case they will be returned.
What number?
I'm deeply
18?
obliged. Deeply obliged.
For 38 application lordship. Yesterday this matter came up before your lordship. Lordship has seen that your lordship was directed to expedite the trial in the year on 9th January 2023. And since then the case is in similar state. And your lordship put a question to me that why you have not filed an application for speeding up. Regarding it, just I'm placing one judgment, your lordship. And before that, lordship may kindly see their final complaint, that relevant portion your lordship will find page 32. Page 32. In their final complaint also, they said that they want to continue further investigation in respect of other accused persons. So further investigation prayer was there. And they have not submitted till date any subsequent report, whether they have completed their investigation, whether it is still going on, no report is there regarding that.
No, that is not the matter before this court, because this is a bail application
Yes,
and final complaint has already been laid against you.
no, that aspect is relevant because lordship, the judgment which I have placed before your lordship, that says if further investigation is going on in respect of other accused persons, and then in that case, lordship, the split up cannot be done. Lordship may kindly see that judgment which I have placed before lordship. In this case, that the judicial magistrate rejected the background of the case, your lordship will find paragraph 3. Paragraph 3. The first information report was registered for the offences punishable under section so against 31 accused. As can be seen from the order dated 16 June 2019, passed by the learned judicial magistrate, that the presence of some of the accused could not be procured. Here also same case. The said order was passed on a petition filed by the accused, second accused invoking subsection 2 of section 317 of the Code of Criminal Procedure. The learned magistrate observed that non-bailable warrants and summons have not sent through the police department, but a report has not been filed by the police department expressing inability to execute the non-bailable warrants or summons. Therefore, the learned magistrate rejected the prayer. A revision application was filed before the High Court by the second accused for challenging the said order of the learned magistrate. In the impugned judgment, the High Court observed that the case was pending from 2016 and the police could not serve summons and or non-bailable warrants to certain accused persons. It is observed that only 20 out of 31 accused were attending the court. After having perused the impugned judgment, we find that the High Court has not even considered the reasons recorded by the learned magistrate in the order dated censure. Secondly, the High Court has not noticed that the learned judicial magistrate on 13 February 2019 had permitted further investigation. Therefore, when the High Court permitted splitting of the trial, two important aspects were not noted by the High Court. The first one was that the learned magistrate was not satisfied that the police have made sufficient efforts to procure the presence of all the accused. The second factor, which is more important, is the order of further investigation passed on 13th February 2019. Therefore, this was not the stage at which the High Court could have permitted splitting of the case.
Whether in this case, the learned court below has permitted the IO to continue further
The Lordship
investigation.
may kindly peruse the order dated 18/12/2022. That aspect was taken into consideration also.
Page number,
That is in the record also. That when the final complaint was filed also. Probably in second bunch of record.
no, here only the pair of the IO is noted.
Yes.
Whether any order has been passed that he is permitted to continue with the further
Without
investigation.
order also they can continue in further investigation, but they have not filed any application that they will not proceed again. They will not investigate further in the present case. Lordship. That is what my submission.
Where is Mr. Kyle?
He is on Lexington court number 7.
Court number?
7.
You call him.
Yes.
His presence is necessary. And this practice of filing part search was deprecated in the case of Ritu Beria, but that has been stayed by the Supreme Court.
Subsequently, it was clarified that bail should not be granted on relying on Ritu Sabra, but that is pending. That aspect is pending.
Clarified.
But it was subsequently said, Honorable Apex Court said, Lordship, that bail should not be granted relying on Ritu Sabra. But aspect is still under consideration of Honorable Apex Court.
Okay, it is already 4:15. No? पहले की मन में क्या सर 30? So tomorrow as a first item,
Oh, Lordship, I have some.
Problem.
Day after tomorrow.
day after tomorrow. Okay,
At 2 p.m. Lordship. At 2 p.m.
okay.
Oh,
First item.
As Mr. S.C. Kyle, learned standing counsel for the NCB, is reportedly in legs in court number 7. And as his presence is found to be necessary here in this case, Resti is directed to list the matter on day after tomorrow at 2 p.m.
Lordship is probably sitting in, Lordship is probably sitting in division bench of 26.
No, single. Day after tomorrow.
Item 19. Well, the petitioner behind the bars for the last 40 days, madam. And my wife is in ICU, madam. Is a very pathetic condition, madam. Is wife. And one mother, son, madam, is one of the son, madam. His mother, able person, able boy, madam. Especially able children, madam. And wife is madam in the ICU, madam.
Yeah.
Is madam, madam.
So
One
where is
of
the
the four-
medical
four-
document?
3 or 4 holes found in her liver, madam. And doctor advised him to retire, madam, admit outside Assam. Very respected. Outside.
When he was arrested?
He arrested on my 16th, madam. 39 days, madam. Wife is in ICU, madam, and son is madam, especially able,
Son is?
especially able. Sorry.
One vehicle was missing, Lordship. Thereafter, actually, one vehicle was somehow missing by one driver, solid, maybe solid in Arunachal. Thereafter, he came and he asked this person that my vehicle was missing in Arunachal, so what to do? Thereafter, he advised him, then you lodge an FIR in Vipuria, I will do the necessary things. Maybe that is not clearly reflected. Maybe Lordship, he prepared one card or something. That is why Lordship. And he should 58,000 rupees for lodging that affair before the Vipuria police station. That is his offense and that is his statement. That is his statement is there.
So what is the disease he has been suffering from?
Vomiting of blood, madam. Madam, 4 holes are recovered from his mother liver.
Pardon?
Liver cirrhosis, madam. And 4 holes are recovered. 4 holes are found, madam.
In her liver. Where it is mentioned?
Madam, the scan report, madam.
No, in the scan report, nothing has been mentioned.
That 3 holes are recovered.
Pardon?
3 holes are found, madam. As mentioned, madam.
To address the. It will लिखा नहीं go to इसको 3 columns grade 3 basis.
That may be, madam.
That is about esophagus. Varices.
Initially, madam, she was admitted to Lakhimpur, madam. Lakhimpur, madam, medical hospital referred to Dibrugarh, madam. Then Dibrugarh, madam, now Dibrugarh Sanjeevan referred her to, madam, admit outside Assam, madam.
Heard Mr. Khonitor, learned counsel for the accused, and also heard Mr. P.S. Locker, learned additional PP for the state respondent. This application under section 413(9) says be heard by accused Deep Setia, who has been languishing in jail as in connection with North Lakhimpur PS case number 64 of 2024 under section 120B 406 420 468 487 IPC. Is to be noted here that above noted case has been registered on the basis of one FIR lodged by SI Dipankar Sangmai of Kalmati Police Outpost on 15/3/2024. The essence of allegation made in the FIR dated so and so is that on 3/2/2024, one Inamul Haq lodged an FIR at Bishpuria Police Station stating that on 30/12/2023, he brought a Bolero Camper 4WD PS car and on 21/1/2024 he went to one of his relatives' house, namely Nasiruddin of Ahmedpur block. And there he was offered to take a dinner. Then the driver, Mirazul Islam, went out taking his vehicle, saying him that he will come from Dongiville till the dinner gets ready. But his driver did not return. And though he called him over phone, the driver did not respond. And later on, he found his mobile switched off. And during investigation of North Lakhimpur PS case numbers 56 of 2024 under section 120B 406 420 IPC, one Inamul Haq was arrested, and during interrogation he disclosed that he sold his vehicle on 1/1/2024 at Dimapur. In a prevalent manner as directed by accused Deep Setia. And before lodging of the FIR at Bipuria PS on 25/1/2024, he, along with another person, namely Nasiruddin, meet Deep Setia and inform him that his vehicle has been stolen at Arunachal Pradesh. Then Deep Setia has taken 50,000 rupees from him and advised him to register the case at Bipuria PS, mentioning the place of occurrence under Bipuria PS area. And asked him to mention the name of the driver in the FIR, attaching the forged document. And apparently, Deep Setia has prepared some forged document in the name of Mirazul Islam,